Good afternoon. Welcome to You're Getting Divorced. Should you mediate, collaborate, or litigate? I'm here today with Shannon Murphy-Barnes, who's of counsel to Peridot Family Law, and I'm Cynthia Runge. Peridot Family Law is a full-service family law firm located in Boston, Massachusetts, and we're here to discuss your various options in the case that you need to go through a divorce process or you know someone who is. So this is a lunch and learn that's going to be approximately 60 minutes, and we have a Q&A section at the end. If you want to put your name into the chat, just please remember that your name might be visible. So if you have any concerns about that, you can plan whether or not you want to have your name there. We can't answer any case-specific questions. However, Shannon and I are happy to speak with you about any questions that you might have about a potential case in a follow-up exploratory call. So without further ado, I'm going to introduce Shannon Barnes, who's going to talk about using mediation in the divorce process. Welcome, Shannon.
Good afternoon. Thank you. So the first question that we usually get when we get on the telephone with a potential divorce client is, how do I get from point A to point B, and what's the best process for me to use? And so we're hoping that today we'll be able to answer some of those questions. One potential process to be used is mediation, and a lot of people ask for mediation because they think that it can save costs, which in some cases it can. What we always like to tell clients, though, is it's important to have at least consulted with an attorney with regard to your rights and responsibilities prior to entering into mediation. But the benefits of mediation are many. Mediation is a confidential process. So rather than having all of your information, yes,
just want to make sure. Okay.
Thank you. So rather than have all your information out in a courtroom or in a litigation process, mediation happens in an office or on Zoom at this point. We do a lot of mediations on Zoom. So that's also helpful. It can be more convenient for parties to be able to do that. But it is confidential. So all of the discussions that take place can take place just between the parties and the mediator. That allows people to think outside the box, to be able to explore a multitude of options that won't be held against them or anything like that in the future. And the neutral that you work with, the mediator, will facilitate the conversation between the parties and help the parties be able to resolve their issues. It's a private process, so you are just the two parties and the mediator working together to resolve things. But the mediator can't provide legal advice. So the mediator is just there to facilitate that conversation between the parties. What that really does, though, is it empowers parties to, come up with their own solutions to problems, to think outside the box, to talk to one another and to kind of work through some of those issues, and to do that in a safe place with the mediator assisting and facilitating. It can also be faster than other ways of resolving issues. You work within your own schedule, you work within the mediator's schedule, and you can really save time and energy. But that also means that, you have to do a lot of the background work on your own. You have to make sure that the parties have exchanged financial documents and done some of the background work in order to get that process going. It can be also cost effective. The parties are sharing the cost often of the mediator, and you can really minimize the use of attorney time as well. So often parties will find that they were able to save some costs. We don't, again, we really don't encourage parties to go forward in mediation without at least consulting with an attorney, having an attorney review the final agreement, whatever it is, and getting that legal advice at some point along the way. But it's not full representation often from the attorney. So you can, again, save some cost there. As far as when you do come to an agreement in mediation, one of the big benefits of that is that when you have come up with your own solutions, when you've mediated your own solution and your own agreement, that often results in people complying with the agreements more as well. So, and post mediation and post divorce, if you have mediated your agreement, if you have thought outside the box and come up with those solutions and to the issues on your own with the help of the mediator, then generally speaking, there will be more compliance in the future with respect to the agreements that you've reached. So you'll, have less conflict in the future when you are working through things with your co-parent or with regard to support, because you've been able to reach those agreements on your own with the help of that neutral facilitator. The compliance rate is often going to be much higher as well. So that is most of what we have to say. But mediation can also be used in post-divorce matters, so not just the initial divorce. We often can see unmarried parties that are separating use mediation to assist them in disentangling their finances, or if they have children, if unmarried parents have children, working through support issues, parenting issues, different things with regard to their own for unmarried parties. So that's helpful as well. You can also use mediation for premarital agreements. Often parties want a prenuptial agreement or a premarital agreement and aren't able to agree on the terms of those things. So mediation can also be very, very helpful in those situations. And as far as the timelines go, if you are able to mediate your divorce matter, then you can just put together the separation agreement, and then you can file what's called a joint petition for divorce, a 1A divorce, that often moves through the courts much faster as well. So as far as timelines go, mediation will be helpful in that regard as well.
Shannon, I know that we're going to do questions at the end, but I was just wondering, what kind of parties can use mediation? What's been your experience around that? Can high conflict couples use mediation?
In my experience, all couples can use mediation. I mean, I wouldn't necessarily recommend mediation in the situation where there's been significant domestic violence or domestic abuse. But otherwise, even if parties are high conflict, the neutral facilitator often can minimize some of that conflict, can help the parties, give the parties opportunity to be heard and clear the air sometimes, to really understand the background of why someone might be feeling the way they feel. So mediation can often help with that. We do recommend oftentimes that the parties have an attorney, again, to work with them throughout the mediation process. And in some cases, the attorneys can even attend the mediation sessions. That doesn't always happen. And more often than not, it will be the parties and the mediator together without attorneys. But in a high conflict situation, you can also have the attorneys present in the mediation session to also help facilitate those conversations.
And one more question, if I may. So,
Sure.
what other professionals might assist as part of a mediation?
And I'm going to talk about collaborative law a little bit later in the presentation, but mediation can also benefit from having a financial neutral or child-related specialist work with the mediating parties. And what a financial neutral can do is assist the parties in gathering the financial information, interpreting the financial information, putting the financial information into the required forms for the court. So there are other professionals that can be involved in the mediation as well, or can be in the background of the mediation to help the parties move forward.
Great. So we're going to talk more about mediation when we get to the Q&A. And now I'm going to pick up from here with something that is actually really helpful to use when you're mediating, and it's called limited assistance representation. So what is LAR? So LAR is essentially a process where it's a form of litigation. And what it is the attorney and the client will work together to define the scope of work that the attorney is going to do. So a perfect example of this is, and we do this a lot, Shannon has a lot of mediated cases, does a lot of collaborative cases. It is not, although we can't do this within our same firm if one of us is representing someone in a mediation or a collaborative case, but if someone is working with a mediator, we can be engaged to review that agreement. And that is really more of a limited assistance role, because many times the mediator in a family law setting is drafting the separation agreement. And then if we're working with someone as an attorney on an LAR basis, we can define that our role is to review that agreement, to provide legal assistance to the client. And sometimes they come to us before the agreement is done, and they might ask for coaching around, what are they, what's the scope of the law? What are they potentially entitled to in a particular situation? So we can help with that. We can help them if they're working with a mediator to prepare their financial statements. We can help them with their joint petition docs, or give them guidance about where they can find information to do these things themselves. Because as you can imagine, people getting divorced, it is as varied as people themselves. On one side of the scale, you might have pro se litigants, and it might be a perfect scenario for that situation if they've got very little to divide, who gets the TV. But it can be very complex all the way up to stock options and businesses and inheritances. So along that way, LAR is a form of litigation, but it allows the client to decide exactly what they want the lawyer to do. And the agreement between them has to be very clear so that the client knows what the lawyer's doing, there's informed consent, and the lawyer understands the lawyer's role. So there's really three basic types of LAR, and some of that is document preparation. And this is something our office, we do a lot of LAR in all of these particular situations. So a document preparation might be that we help somebody put together a complaint for contempt or a motion. And those documents at the bottom would have, some language that says prepared with the assistance of counsel. Sometimes someone might reach out to us because they want us to go with them to a particular hearing. They have a motion hearing that's really important. They have a pretrial hearing, or they have the divorce hearing. They want someone to be there just in case anything comes up. And sometimes, we're engaged because folks are looking for advice or counsel. If someone's looking for alimony, they want to understand, what does the law provide? What are the different types of alimony? So basically, this provides litigants, not just in probate and family court, but in other courts. Our practice is focused on family law, but there's information on the mass.gov website about LAR. And it also is if you're looking for an attorney, it's broken down by county. So if you have a case in Plymouth County, you might be more inclined to want to find an attorney closer to you. And you can look on that list and contact those attorneys and see if they're willing to help you with your particular situation. So as we discussed, LAR basically puts limitations in the scope, and it requires the client's informed consent. What does that mean? Well, it means that we have an agreement that really just lays out exactly what the attorney is going to do. And when I prepare an agreement for a client, I always send it to them in advance and say, have I got everything that you want me to do? A lot of times their list might be shorter than mine. And so I'll have to ask questions to say, are you also going to need help with this? Are you also going to need help, getting documents? So that's our role, is we kind of know what to ask when we work with someone. The other thing is, sometimes when we work with someone on an LAR basis, you're not limited to just that one task. So let's say someone engages us to go to a hearing, and then they decide, well, I'd like you to help me with some discovery. You can always do a different LAR agreement, or you're not limited to change it to a general representation. And we're going to talk a little bit more about that towards the end of the program when we get into litigation more specifically. But at any time you're doing a different agreement, like your LAR agreement is to do task X, Y, and Z. If you're going to do an LAR agreement for task A, B, and C, there's either going to be some sort of amendment or something in writing that clarifies that. So the important thing about LAR, and this falls on the lawyer as well as the client, is to make sure that the client really understands, the scope of limited representation. So for example, I can't think of a time when I've agreed to get involved in like a custody case where somebody's sort of in and out. And the thing is, the reason for that would be, it can get too complicated if you're not in, like if you have a certain type of case. If you're not involved throughout the case, certain things could potentially get missed. So that would be something that the lawyer would explain to the client and say, based on your particular situation, I don't think that this is a good case for LAR. Another situation where LAR might not be appropriate is, like, say the client wants to take on a lot of the roles themselves. So for example, a client says, I want you to prepare the documents for me, but I'll get it filed and I'll get it served. I've had folks come in and, maybe say that, and then they try to do it and they get confused, or it doesn't happen the right way. And so I end up having to do it. So those are things that we try to give our clients feedback about so that they can make informed decisions. It's not to say that you can't change your mind later and do a different agreement or a general representation, but you also have to kind of look within yourself and decide, is this really, the situation where I can really handle all these tasks. So that's something that you definitely want to talk to your attorney about, or when you're looking for legal services. So moving on from here, unless Shannon, you have any questions about LAR. Oh, I think
Sorry, I was muted. Sorry about that. So
no worries.
I'll ask you some questions about that at the end, if that's okay. I do have a few follow-ups, but
Sounds good.
I think as we talk about all four things, then we can then wrap the pros and cons together. So collaborative law. Collaborative law is one of my favorite things to talk about. I truly believe that family cases don't belong in court. especially when there are children involved. I always say that, parents are going to be parents forever. You're not just co-parenting until your children are 18. You're going to have to deal with college issues. You're going to have children that get married, or you're going to have grandkids in common. And the worst thing for a child is to feel uncomfortable when their parents are in a room together, whether it be a 12-year-old child, a 20-year-old child, or a 50-year-old child. No one ever wants to feel uncomfortable when their parents are in a room together. So the focus of collaborative practice is to really develop those post-divorce relationships to help the parties solve their problems jointly, to prevent court involvement, and to have parties come to agreements on with the help of the collaborative team. So any attorney that helps or that represents a party in collaborative divorce needs to be collaboratively trained. And so the team is generally made up of 2 collaboratively trained attorneys, a collaborative coach or facilitator, and usually a financial neutral. Often the coach facilitator is a child-related specialist, but sometimes they can be more of a coach that has helped parties through transitions in their lives or those sorts of things. And one of the beginning stages of the collaborative divorce process is to really dig deep and set goals for each of the parties in the process, to figure out what the parties really want and need out of the process, to find out not just what their position is on certain things, but to really dig down and find out why they want the things that they want, why they are asking for a certain parenting plan or a certain division of assets. And often when you dig down into the why, you really are able to expand the amount of options for resolving the issue. So more about the team. The team approach, the collaboratively trained attorney, is really focused on one thing: settlement of the divorce matter. So when you hire an attorney in a traditional sense in a divorce matter, the attorney is tasked with 2 very different things that don't intersect. The first is settle, try to find a resolution, try to find a parenting plan that works for the parties, try to find support and property division provisions that work for the parties. But the other thing that the attorney in a traditional sense is hired for is to prepare the case for trial. And to prepare the case for trial, you're not really focused on resolution. You're focused on what your position is, how to assert your position with the court, how to convince a judge that you're right and what you want is what the resolution should be or what the outcome should be. But in collaborative divorce, what you're really doing is you're compromising. You're focused, and the team is focused on resolving the matter in the way that's most beneficial to everybody, so that everybody in the process, including the children or other people involved. I mean, often in a divorce situation, it's not just the relationships between the 2 parties, but there are brothers-in-law, sisters-in-law, mothers, fathers that are involved as well. And sometimes people want to preserve those relationships. And those relationships over the course of a marriage have been very important. So the collaborative process really allows the parties to try to preserve some of those really important family relationships. The other thing is just taking the approach that the parties are going to come up with the solutions. You're not going to go to a judge who's only going to have a limited amount of time to hear about your family, to hear about your finances, to hear about your life, to then make decisions about how your life is going to look going forward. The parties and the family really take control of that. And they say, you know, we don't want a stranger in a robe that's paid by the state to tell us what our life's going to look like moving forward. We really need to be able to figure this out. So, and one of the hallmarks of the collaborative process is that you actually sign a contract between all the parties that says, if this process doesn't work, then we basically, the attorneys cannot be involved anymore. Some of the work product of the neutrals won't be involved, won't be available. So what that does is it really keeps people engaged in the process. They want to figure out a resolution. They want to stay in the process so that they're able to come to that resolution without having to then resort to litigation and kind of start fresh. So that's one of the really important pieces of collaborative law is everybody's committed. Everybody's committed to having these meetings, to making some compromises, to figuring out what the goals are, and to really reach a resolution on all issues. Often, this will work well for families with some limited resources, because what the parties agree to do in collaborative law as well is, instead of having two appraisals of the marital home and a lengthy court battle about which one is correct, the parties agree to hire joint experts. The parties agree to appraise a home jointly and to work within the joint appraisal process. The parties hire a joint financial neutral. So instead of fighting over what documents are going to be produced or whether or not the documents are needed, the financial neutral is really going to guide both parties to provide the things that the process needs. There's no cat and mouse game between, you know, oh, I asked you for this document. In the collaborative process, everybody's working as a team. If one party says, I really need to have this document or this piece of information so that I have my peace of mind, then the team will provide that. It can be faster, which will also sometimes save costs. The parties are going to work at a pace that fits their needs, their schedules. And so you're not waiting for the court to schedule things. This was especially important over the last couple of years, and even will be important going forward, because COVID delays in the courts have backed things up significantly. And so the collaborative process allowed divorcing parties or people that were working within the collaborative process to really meet at their own pace and to not have to wait through those court delays. And as far as for attorneys, you know, we are working towards settlement. We're not worried about, oh, well, what if this doesn't settle? What if this, am I ready for trial? Have I prepared my client for what a trial is going to look like? So it allows the attorneys to really focus more on what the family's needs are. I think I've covered most of what I wanted to talk about as far as collaborative divorce goes. Cindy, do you have any questions before we move on to the next?
Yeah, just a couple based on what you just said. So can you talk a little bit about what happens if one of the parties files when someone's working collaboratively?
If like during the collaborative process, if somebody files? Well, the collaborative agreement at the very beginning allows a time period. If one of the parties wants to withdraw from the collaborative process for any reason, then there's a notice requirement and different steps that have to be taken. And that's going to be set out right at the beginning of the process so that the parties know what they, you know, what their responsibilities are if they want to withdraw from the process.
And how does somebody find a collaboratively trained attorney? Like lots of lawyers say they're collaborative.
So, well, you and I are involved in the North Shore Collaborative Divorce Group, which has several attorneys that are collaboratively trained, neutrals, that sort of thing. Outside of the North Shore and statewide, we have the Mass Collaborative Law Council as well. So those are two great resource websites as well as to learn more about the collaborative process, to read some articles on the collaborative process, and to really find out the best way to get started.
Great. Well, I have more questions for later. So the next thing to talk about is what most people know about from watching TV. You know, the only difference between, well, there's a lot of differences between real litigation and TV litigation. The first of which is that most litigated cases are not resolved in 60 minutes. So what is litigation? Although most cases can be resolved through dispute resolution, and litigation is also a form of dispute resolution, some cases are unable to be resolved short of litigation. In these situations, the judge has to make the decision for you. Even if you have to go the route of litigation, and what does that mean? It just means that you're going you're going through a more traditional route, which is somebody files a complaint, you know, for divorce, and then it's served on the recipient, and then that starts a timeline. There's dates that are implemented so that people have to comply with exchanging financial information. There's a rule 410 that requires people to exchange taxes, bank statements, retirement information. And the reason for that is to help everyone be on a level playing field, so that everyone has the same information, so that when they're talking about trying to settle or resolve a case, people really understand what their rights are as well as what's at stake. So in that sense, litigation can be helpful, because without timelines in place, some situations will stagnate. But that's something that you want to discuss with your family law attorney who's representing you. So what types of cases can be litigated? Well, certainly divorce. And you know, litigation doesn't have to be World War III litigation. There are plenty of cases that we have where we work cooperatively with the other side. You know, our duty is to our client, but at the same time, we can still work with the other side fairly and equitably. But as with any process, you know, people's personalities can be very different. So sometimes it can be smoother than others. And so it can be really helpful to speak with your attorney to get a sense of, you know, what to expect in the event that you have to file a complaint for divorce. Alimony cases. So once you have a judgment of divorce, there's going to be certain orders that are going to be in place. Sometimes after that order, people need to resolve disagreements about other financial matters. It could be alimony. It could be, you know, that under the current law, if someone is cohabitating under the, you know, the Alimony Reform Act, that can be grounds for terminating alimony. So there could be what's called a modification judgment. And one thing about litigation is it's, generally speaking, not quick. There are workarounds, and you can speak with a family law attorney about that. So for example, if you and your spouse or former spouse are able to agree that alimony should be modified, and you can agree on the amount, you can submit what's called an assented to complaint for modification, and that can be heard administratively. So that can save you lots of time, stress, and money. Same thing with child support. As kids get older, the child support guidelines, once a child is over 18, and once there are college costs involved, that can also impact the amount of child support that someone's receiving. Parenting plans. Parenting plans can also change. If a former spouse decides they're going to move, they might need to file a removal case, or there could be a remarriage that impacts the parenting plan that was in place at the time of the judgment of divorce. Children's education in college, that's a big one. College is very, very expensive. A lot of times when people have really young kids, they kind of kick the can down the road in terms of what's in their agreement about how they're going to deal with college education, because it's really hard to even imagine what you're going to do next year, let alone 10 or 15 years from now, if your children are really young. So depending on people's financial circumstance at that time, those are big issues that can be modified, or that you can agree on and change what's in the judgment of divorce. Health insurance. People move around, they change jobs. There are some instances where, through a judgment of divorce, that someone who had previously been covered by health insurance can no longer be once the divorce is final. So health insurance can be a big issue. It's certainly something that we spend a lot of time talking about when we're going through the divorce process, because people need to know how they can get coverage. In modification situations, if there is coverage post-divorce that's in a judgment, it can simply mean that when the party who had the coverage goes to their next job, that the way the agreement is written, it can allow that new employer to provide health insurance, as the parties had discussed. And we just talked a little bit about modifications. Basically, that's anything that comes after the original judgment. Heartstrings versus purse strings. So divorce is not an easy process, even in the most, in cases where people get along as well as they can, if they're still going through a divorce. It's very hurtful, it's very painful. Sometimes we hear really sad stories. People have been married for a really long time. That can cause folks to get angry. It can cause folks to, want to pursue a very acrimonious type of case in the court. But our experience has shown us that rarely produces the result that is hoped for. And we really strive to work with clients who are mindful about that this is a difficult process at best, and that they want to move forward in the most positive way they can for themselves and their children. So it takes a little bit of reflection, because let's face it, if you're going through this process, you would just want it over with. And you need to be able to pause and slow down so that you can really understand what are the issues that need to be resolved, and to really be able to think about them and have time to see, like, is this parenting plan really going to work? What about someone's ability to pay support versus somebody's need? These are all things that need a little bit of time to sort through. So the other thing is, everybody has a neighbor or a friend who has, heard of somebody who got this or got that in a situation. And the truth is that your lawyer, whoever you choose to work with, is going to have to help you be realistic about what you can expect to accomplish if you go through a litigated process. And part of that too is also just the timeframes involved. We as practitioners rarely have control over that process, because there are just so many cases, and COVID definitely slowed things down. Newer cases where people agree tend to go through quicker. But you want to work with someone who's going to be reasonable with you and give you the skinny on what to expect if you have to go through a litigated process.
Yeah, I always like to say it's like a realistic expectation of what's going to come of the process, and a little bit of a reality check. And also, I find part of our job in any one of these cases is, as an attorney representing a divorce client, is to, help the client figure out ways to deal with the emotional aspects of what they're going through, because sometimes that can drive decision making, and sometimes in a negative way. If people are upset or angry, they make decisions that they wouldn't otherwise.
And that's a good point. And I think, what we hope to accomplish with this presentation is to just sort of give you a sort of a spectrum of the different ways that you can go through a divorce process. Some of these processes work really well together, mediation and LAR, collaborative law as its own process, which is kind of a hybrid of mediation and litigation because you have your attorney there present. And then even in litigation itself, there's a spectrum of what it can look like. And so with that, Shannon, let me ask you, how does somebody know if mediation is right for them?
I always say that kind of the first step in the divorce process is to talk to an attorney and to, maybe just do a 1-hour consultation and have one of, our firm does these quite often, right, Cindy? But just, sit down with an attorney one-on-one, give the attorney some of the details of your life and your case, get, a case review or a real overview of what you can expect from the process. And then you can decide and go from there and decide which process might be best for you. Do you need a little bit more hand holding, or will you feel comfortable going into a room with a mediator and your spouse or your significant other and really just having someone facilitate that conversation? I think mediation, like I said earlier, mediation can work even in the most high conflict situations. And it really does work well. But some people really will need a little bit more handholding. So you might decide to go with another process if that's the case, and if you know that about yourself. Just going back to litigation, Cindy, because that was one of the last things that we talked about. Can you tell what are the average costs of litigation?
Yeah, that's a tough question. And it really depends on the type of litigation case. I've talked to different practitioners, and I know from our own experience, custody cases can be very, very expensive if they're contested. It can be anywhere from 50 to 100,000. It depends on, because you're involving a number of professionals, guardians ad litem. Sometimes they're involved more than once. And, in contested cases, the more an attorney has to prepare motions and go into court, that's where the bills are impacted. So to the extent that folks are able to stay around the table and, it doesn't mean that you're going to sing Kumbaya, but it means that you have a commitment to try to resolve things. And for you to set your own parameters, that's going to go a long way in terms of how you feel about this process 2 years from now, and likely in how much money you're able to spend on yourself and your family going forward.
So you just mentioned 2 years from now. That can a person in litigation expect to be involved in the process for 2 years, or how long does it usually take?
Depending on the court and depending on the issues, depending on how many times, if your judge gets reassigned. There are a lot of transitions going on in the courts right now. 2 years is not unheard of at all for litigation. It can take longer. Yes.
And going back and looking through kind of all the things that we've talked about here this afternoon, what would you say is the most cost-effective way to get divorced?
Whenever people contact our office, we really try to steer them in the direction of mediation or collaborative law. And the reason for that is because not only do we believe that they're going to get a better result because it's primarily, both processes require the participants to be very much involved as opposed to the lawyers. But we also recognize that sometimes the other person may not want to participate in those processes. So we can we can also assist them if their case gets back into a more of a litigated process.
I actually get that question a lot about, how if I decide that collaborative law is right for me or mediation is right for me, how do I get my spouse to participate in that as well? How do I get my spouse on board?
What's your answer to that?
I usually will explore that with a client and explore the options of, whether or not there's what the communication level is between the parties when they first come in. And if the communication, is reasonably open, although it might not be great. And like you said, they might not be singing Kumbaya, they might still be, talking and co-parenting and things like that. So the parties can sometimes have that conversation. And I always tell parties to, if they are able to have that conversation, to, steer their spouse towards the North Shore Collaborative Divorce website where they can learn more, or the Mass Collaborative Law Council website where they can learn more about collaborative divorce and hopefully get on board. Another way is for the parties to maybe engage one of those neutral facilitators as the first step in the process, so that the neutral coach facilitator can work with the parties and get them on board and kind of steer them in that direction. Sometimes the attorney writing a letter to the other side and saying, we want to be amicable and we want to try to resolve this and we want to do this in the way that's best for you and your family, and steering the parties toward the other party towards those resources. So it's a case by case analysis, but there are a lot of different ways to really get that other party involved.
Speaking of resources, on the Peridot Family Law website, we have a tab for resources. And in addition to some of the places that Shannon just mentioned for collaborative law, we also list the Mass Counsel for Family Mediation. We encourage you to talk to people, and you want to find a professional and professionals to work with who you feel really confident with, and you also want to feel comfortable. You don't, sometimes we hear stories that, someone's looking for a pit bull attorney. That's not always the most productive way to approach litigation, because if you really want to get through the process and not have it go on for years and years and spend hundreds of thousands of dollars, that approach may not benefit you. So there are better ways to think about. Speaking of,
and I would love to interject there that, in my career, I've been practicing family law for, 25 plus years at this point, and recently joined Peridot Family Law. And one of the attractions and one of the reasons why this firm was such a great fit for me was the approach, the real personal approach that you take and that your staff takes to providing services for clients, and really working with the whole client, including those emotional aspects, and helping the client get through those emotional aspects so that they can make the best decisions. And we aren't just raising the sword and saying, oh, you're angry, so let's run to court. We really work with the clients to make sure that they're making good decisions, and if we're going to court or if we're doing other things, we're doing it for the right reasons.
And thanks for saying that. And that's why Shannon's such a great contribution to our firm. So we're really lucky that she's with us. Shannon, I wanted to ask you also about mediation. Some folks have asked, how long or how many sessions does it usually take to finish an agreement?
It's interesting. I've had mediations where, we've had one session and we've gone through all the issues, and with the help of the facilitator and the mediator, and Cynthia and I both are trained mediators. With mediation, it could be one session or it could be 10. And it's hard to predict, but there are cases that we can guide the parties through the things that need to be talked about, and we can do it in a very, very efficient manner and really get to the outcome in just one session. What's the average? I would say probably 3 to 4. in a divorce case with multiple issues, with property settlement issues, support issues, parenting plans. Often there's homework in between that parties need to do, or research that parties need to do, or they need to exchange more financial documents or get more information. So I would say average 3 to 4 sessions, but it can be done in less.
Shannon, do you also use limited assistance representation? And if so, what kind of cases do you like to work on?
So I use limited assistance representation a lot. And I think it works well for parties that are in mediation. They can get some advice and counsel between mediation sessions. It works well for parties that are having difficulty, that are in litigation, or maybe don't have the means to hire an attorney to represent them throughout the entire litigated process, that might need help with discovery or help drafting motions, or in between court dates getting some information, some advice and counsel. So I use LAR a lot, and I think it's a great tool for parties.
Just trying to think if there's anything else we can add here. Let me just check to see if there's any other questions in the chat that we haven't addressed. And I think I got them all.
Excellent.
Any closing remarks?
Well, thank you for having me and inviting me to participate in this today. I think this is, like I said, one of the biggest questions that people ask at the beginning of the process is what do I do and how do I proceed? So thanks.
Great. And as we said, although we can't answer any case specific questions right now, if you're interested in getting some feedback about a question you might have, reach out to Shannon or myself at Peridot Family Law, and we're happy to do an exploratory conversation with you and talk to you about your options. We really want to thank you for attending, and we look forward to working with you in the future. Thanks very much.
Great. Thank you.